and good to have you with us at the 9 p.m. Urban Debate show here. Tonight, we put the spotlight on one of the big controversies that has got everybody talking, from the political circles to the legal circles. Retired Supreme Court judges, top lawyers of our country are talking about it, and this pertains to a case that's going on in the Supreme Court right now. A case of contempt proceedings, criminal contempt proceedings against Prashant Bhushan, a noted lawyer. Now, the Supreme Court has already found him guilty of contempt because of two tweets that he put out. And these tweets were regarding the Supreme Court, one specifically about the Chief Justice of India, the other one about the Supreme Court and former Chief Justices of India. In the light of that, the Supreme Court has found him guilty of contempt, but they're yet to decide on what his punishment should be. Today, amidst all this controversy and conversation and letters being written to the Supreme Court by lawyers and politicians, about rethinking their decision, the Supreme Court did ask Prashant Bhushan if he wanted to reconsider his statements, he wanted to withdraw them, apologize for them. And Prashant Bhushan said, no, I'm not going to do that. I believe in what I said. I believe I did nothing wrong. Let me, in fact, take you through what Prashant Bhushan said in his statement. And he told the Supreme Court that I have been grossly misunderstood. My tweets are attempts to discharge my duties. Apologizing for it would mean a dereliction of my duty. I don't want to reconsider my statement. I am not seeking mercy or magnanimity. What I said in my tweets is bona fide. Now, the Supreme Court still has gone ahead and given time to Prashant Bhushan for 2 days. And then they will decide, basis whether or not he reconsiders his statement, on what should be the sentence, what they should pronounce as the punishment for this contempt. Viewers, I am not going to sit here and discuss about one case or judgment being right or wrong. But I think this is an extremely important point in our lives, in the country right now, where so much is being said about contempt, to try and really understand what is the contempt law. Just in what kind of instances is it usually used? Should it be used? Is criticism of the court, of any judge, really about contempt? Should we just do away with contempt proceedings? What exactly is this law? Now, from a common man's point of view, somebody who's not an expert in law, I ask these questions to 4 panelists, 4 experts in law who are joining me this evening on this conversation. So let's say good evening to Karuna Nandi, Senior Advocate with the Supreme Court, Mr. Kailash Vasudev, also a Senior Advocate with the Supreme Court, Anup Chaudhary, Senior Advocate and former Advocate General for Madhya Pradesh, and Sanjay Hegde, Senior Advocate with the Supreme Court. Thank you so much to all of you for joining us in this conversation. I actually want to begin by asking a couple of you to decode the contempt proceedings, contempt law for us. Sanjay Hegde, if you can explain it to our viewers, and what is this law?
Well, the Contempt of Courts Act is basically an act which is designed to ensure compliance of the court's judgments and for not necessarily speedy, but for expeditious administration of the courts. If you challenge the authority of the court or you somehow hamper its functioning, then you may have caused criminal contempt. For instance, if you threw a shoe at a judge, or you sat at the back of the court and raised a protest, you disrupted court proceeding, then that would be criminal contempt, and it would be criminal contempt in the face of the court. There are other contempts, civil contempts, when possibly a court order is not complied with. They stand on a different footing. Now, this particular conviction is under 2C1 of the Contempt of Courts Act, which basically says anything that scandalizes or tends to scandalize the court or to undermine its authority. That is the section under which Mr. Bhushan has been convicted. The Supreme Court has determined that the 2 tweets which were brought to its notice have undermined the authority of the court, and therefore, first there has been a conviction, and today there was a hearing on what was the appropriate sentence to pass on him. They have finished the hearing, they've reserved the judgment, and in their order recording the proceedings today, they have said that we've given him 2 more days to further consider his position and tender an unconditional apology if he is so minded. That is what has happened so far.
Okay. In fact, the two cases that come to my mind, two instances, where which grabbed the headlines. Of course, one was the contempt proceedings against Justice Karnan, a judge himself who had sentenced and issued a sentence of 6 months, who was sentenced to 6 months imprisonment after contempt proceedings were carried out against him. And this is because he himself put an order against the Chief Justice of India at that point of time, J.S. Kehar, and 7 other judges. And that was the reason why he was, made to face these proceedings. The other one was actually after that. And that one included the then CBI Additional Director, Mr. Nageshwar Rao. Of course, that was more to do with presenting a case and behavior, in terms of a court proceeding, where the judge then told Nageshwar Rao to sit in one corner of the courtroom till the end of the day. So the punishment in this case can go from sit in the corner, pay a fine, or go to jail. Now, that's a vast, set of options, Mr. Kailash Vasudev, for contempt proceedings. But in essence of it, are they usually used for what happens within the courtrooms, or if you skip a hearing, or if you, show disrespect in the court, or also outside the courtroom, which is what happened in this case?
Good evening. See, we must get the perspectives of contempt. Contempt is civil and criminal. Civil is when you're in disobedience of an order of the court, or you have given an undertaking, not followed it in certain areas. Criminal is when you do something within the court complex, the judge, and it's in the court hall. Essentially, that is a concept of criminal contempt. It can also apply in circumstances where you make an unfair criticism of or scurrilous criticism of a particular judge. But please remember, it must pertain to the court, it must pertain to a judge. In Karnan's case, which I personally feel is a very wrong judgment, where you convicted a judge, a sitting judge of the High Court, on the basis that he was making scurrilous statements which impacted the judiciary. Contempt is of a court, contempt is not of the judiciary. And in the Karnan case, there was a bench of 7 judges, 4 of which were judges who had made statements in a public press conference at 11:30 on a particular day in the month of January. Gogoi, Chelameswar, Lokur, Joseph. All these 4 gentlemen had made statements that there is something terribly wrong in the judiciary. When Deepak Mishra was the Chief Justice seeking rectification, they did exactly what Karnan had done outside. Karnan only said they were corrupt. These gentlemen said there is something seriously wrong with the Supreme Court. It is these bunch, I use the word, group of 7 judges sitting in a constitution bench, which holds Karnan guilty of contempt. This judgment in Karnan must at some point of time be reviewed. It has to be set aside. It is a precedent outside the Contempt Act, my view. Let's come to the judgment in Mr. Prashant Bhushan's case. It is a tweet. It pertains to a particular action. The action is not in court. It is the view of a gentleman who said, look, I feel that this should not have been done. That's the subnum bonum of it. And it is based on that tweet that you turn around and say, no, he's committed the grossest contempt. He has criticized us. He's taken a view against the Chief Justice, which is uncalled for. Once again, you are exercising an authority, taking it upon yourself suo motu, that is by yourself, for initiating proceedings on an event which does not happen in court. In every free democracy, criticizing a judgment of the court, criticizing a judge, criticizing a situation emanating in court does not amount to contempt. We have got, at some point of time, to have broader shoulders to accept this. Justice Karju in 2010 said the same thing. He says these kind of words don't break bones. If words don't break bones, I'm going to do my job and I'm not going to be deterred by it. Karju was controversial in his own time because he was an outspoken man. But he had the courage to say what he had to. He said things in the interest of the system. So today we are at a point where we are moving into loggerheads. You have statements by retired judges, you have statements of all kinds saying that this judgment is improper. It will be an infringement of the right of free speech. If it is free speech, you cannot curb free speech by way of contempt. You don't have the powers under Article 19(2), which restricts these things. In the judiciary, you've got to be circumspect, you've got to be more open to criticism because your judgments can be controversial, whether it is nationalization of banks, whether it is rapes, whether it is murders, whether it is Prashant Singh, whatever. Those judgments are open for criticism. And the right to criticize, you cannot take away, not by exercising powers in contempt.
Okay, let me take that point across to Mr. Anup George Chaudhary. And Mr. Chaudhary, your view, to your mind, what constitutes as contempt, to what, and where do we draw the line?
My view is that the judgment is horribly wrong. And the definition of contempt of court has been altered, amended, as though the Contempt of Court Act stands amended. Article 129, to which the bench is supposed to have exercised the power under Article 129 of the Constitution, that also stands amended. Both these provisions, what is important is the contempt of court. There is no Contempt of Judges Act. Even in Article 29, when it gives the power, inherent power to the Supreme Court to punish, is for contempt of itself. Itself means Supreme Court. You can't substitute the word judge in place of Supreme Court. And the whole approach, one basic, I would say, illegality is there. Evidence Act prohibits any tweet or anything that comes from the net to be considered as evidence unless the provision of Section 65B of the Evidence Act is followed. Now, how do you take cognizance of a tweet which is in law in the Evidence Act not admissible? You can't take cognizance of such a tweet if it's not admissible. Second aspect is, the question is, court says a suo motu. But I'm sorry, there was an application filed by some lawyer called Maheshwari. Once an application has been filed, that application was placed before the court. Now that also is, I don't know how it was done and how the registry placed it before the court, because it is, the law is that in criminal contempt matters, the permission of the Attorney General is important in the Supreme Court, as it is important in the High Court. The Advocate General has to be, and the permission of the Advocate General has to be taken. Therefore, if you move an application, I don't know how that application was placed, and the application is considered, and the bench says we are exercising the power suo motu. Those two things don't gel together at all. They are inherently contradictory to each other. Moreover, there have been so many occasions. If you remember, the 4 judges said that the democracy is under threat. Now, I don't think there could be a bigger indictment of the Supreme Court than by the 4 sitting honorable judges. And everybody kept silent. Even today, Justice Lodha has come out very openly, and Justice Kurian and Justice Lokur, then send them a contempt notice. But it's not so. You must realize that all these people are, even as Mr. Bhushan had said, that he is as much concerned about the majesty of the court because he is a part of the court. He is appearing every day in the court, and he has been responsible as appearing for the PIL petitioners for several important judgments. But apart from that, I would not like to make it Bhushan-centric because most people have made this as Bhushan-centric. And then some bar councils will be managed to pass resolutions approving the judgment of the court where it's not required at all. The Supreme Court doesn't require approval or disapproval. It has to face criticism. For example, Chief Justice of Bharucha, as he then was as Chief Justice of India, had said there is corruption 10% in the higher judiciary. Was that contempt? No, it was not. Similarly, so you can't have, parameters have to be, what is the fundamental ethos of the Constitution is lack of arbitrariness and equality. Equality is to be practiced everywhere. Now, if you can't choose to ignore one statement, why? Because it's your former colleagues have made it, and then if the same kind of statement comes from a lawyer, then he has to be pulled up for contempt. And like I said, and all the lawyers, by the way, we all are of the same, I can't say about my friends here, but several of the lawyers are few, that this was not a case where any contempt was made out at all. One aspect was taken umbrage of by the judges while the arguments were going on, that you criticize the Chief Justice of India, Justice Bobde, who was sitting in a civil across, riding a bike, and he was not wearing a mask or a helmet. And now that was an honest mistake by Bhushan, just what he says. He says, I didn't realize that the bike was stationary.
Yes.
But all the same, how does it bring down the
majesty? Yes, he did say that during the hearing, that I didn't realize.
It's a
correct. I mean, he's admitted the mistake, Mr. Chaudhary, where he said that I didn't realize that he wasn't riding the bike at that point of time. He was sitting on a stationary bike, and that is my mistake. But of course, that being clarified, Mr. Bhushan says that I am going to stand by my tweets. I will not take them back.
It is criticizing an action of an individual judge. Now, if a judge goes in a particular attire in the court and somebody says, well, you're not formally attired and you're wearing chappals and walking with pajamas, does it become a contempt? It does not. It does not become. That's the whole issue, is whether this criticism becomes contempt. He's talked about 4 former Chief Justices of India, whatever way. They are no longer judges. It's not a contempt. It may come if they feel like that they've been defamed. There's a law of defamation is there. That's a different matter, criminal as well as civil. But it's definitely not contempt. The whole definition is being changed from contempt of court. I said earlier, I'll repeat it again, it's not Contempt of Judges Act. The power of 129 is not for contempt of itself, means the court, not of its own, if it judges who are sitting in or not sitting, even those who have retired. Even that was taken account of. How have you named the 4 former Chief Justices of India? I mean, of course, the court is entitled to its final
let me just bring in Karuna Nandi also, Mr. Chaudhary, and I will come back to you for 4 of you. Your names come up in that letter that you've written, very strongly, unanimously saying that you do not agree with what's happened. Karuna Nandi, even though some of the lawyers, even in that group of 41 lawyers, may not agree with what Prashant Bhushan said, but that doesn't mean that you back the action. Now, I'm trying to understand this difference, and not necessarily in reference to Prashant Bhushan's own tweet, where you say that we don't understand, we don't back what a certain person has said in terms of criticism of the judiciary or a court or a sitting judge, but that's different from a contempt proceeding. Where again how do we make this distinction?
Voltaire said it better than I ever could, is that I may disagree with you, but I will fight to the death for your right to do so. And that is the foundation of a lot of the free speech thinking in globally, really. The thing is, just one correction is that the 41 lawyers that you're speaking of were the original signatories. Since then, there have been 2,000 lawyers. When I last checked 2 days ago, it's probably a lot more now, that have signed that particular letter. 7 former Chief Justices have signed a statement regarding this issue, and, many, many more people. 7 former, not Chief Justices, 7 former Supreme Court Justices. I do beg your pardon. Now, let us look at where this law of contempt comes from, Tanvi. It came from early modern England, where there was a newly anointed parliament, and the courts were to be protected from too harsh criticism at the time. And let us remember that at the time, acknowledgedly, the court was an extension of the executive. It was not separate. Now, this was brought into India. This particular concept was brought into India, and there was huge debate in the Constituent Assembly about what types of contempt should remain within the Article 19.2 exception to Article 19.1, which is the right to free speech. Let us remember, if it is not limited, then it is your right to free speech, right? It's a constitutional right to free speech. There are 3 kinds of contempt. One is if the court makes a judgment and you refuse to obey it. Now, of course, the courts must be clothed with the powers to act against that. Otherwise, there's no authority whatsoever. The second is that if there is interference with a fair trial, if there's prejudice of a fair trial. And the third is what we are most familiar with, I think, which is scandalizing the court, right? Now, with regard to the third, it was considered to be too broad, and in 2006, Parliament limited this to substantial interference of justice, and also Parliament has brought in a defense, which is the defense of truth. Now, substantial interference of justice is not a low threshold. And so far, unfortunately, I don't think that it's made an appreciable difference to the way our courts all over the country have dealt with contempt law. I think that part of the reason that judges feel attacked, when statements are made or when allegations are made, is because they can't really speak out in the media, right? They can't, there isn't really a body that can look at these allegations in any way. And so on the one hand, you have people making sort of complaints and saying that, look, this is happening and I am anguished by this because this is my court. And this is where I have devoted my life. And this is where I am, this is my karma bhumi, right? And I am as invested in this as anyone else. And when there are particular concerns, then there is anguish that is expressed. So, for example, Iqbal Chagla, who's widely considered a lion of the bar from Bombay, has written a piece about how he made particular statements about corruption of particular judges in the Bombay High Court. And he backed them up because he did not make these statements irresponsibly. He took these then to the Chief Justice, and the action was taken against the judges that he had made the allegations against. And so there was a salutary effect because he had made the allegations responsibly, there was a salutary effect on the process and the course of justice and the temple of justice, really. I do think that having an independent institution, a National Judicial Academy that doesn't have I beg your pardon, a NJAC, which doesn't have a veto by the government, but that is truly independent, a body that can really look at allegations and deal with them so that neither on the one hand do judges feel helpless and feel the need to, resort to this very, very draconian power, which I feel has actually been limited by statute and should be limited to the substantial interference with the substantial course of justice, which is a high threshold. And on the other hand, people don't feel that there is a proper way in which people can make, substantiated allegations where they are true.
Okay, I have a couple of follow-up questions to that. Let me take it to Mr. Sanjay Hegde first. Mr. Sanjay Hegde, many say that the contempt law and the wide interpretation of the contempt law itself is very dangerous. You're actually looking at a situation where a judge is getting to decide, issue proceedings and decide on it all by itself, which isn't fair. Do you think in that sense then maybe we need to be a little bit more specific in our law about where contempt is valid?
Drawing the line again as a legislative device may not always be possible, because there are various ways that the administration of justice can be thwarted, and where the contempt law could come useful. So the safeguard has already been provided. The safeguard has been provided by asking for the Attorney General's permission before contempt proceedings are launched. Any private party who wants to launch criminal contempt has to take the Attorney General's permission. And Attorneys General don't give it freely. I have worked with a senior who was Attorney General, and this time he would check the facts of each case, and at times he declined permission. Now, after that, then if permission is declined, you can still go to court and say that the Attorney General got it wrong. But here, where the bench did not insist on Attorney General's permission, they got the Attorney General to later on assist them, made him sit through the proceedings for most of the proceedings, and only turned to him right at the end of it. They put the cart before the horse. There was a procedural safeguard, they should have adhered to it. Because the Attorney General is not only the government's top law officer, he is Attorney General for India. He performs a constitutional duty. And one of his duties is to be the guardian of contempt. This court proceeded suo motu and said that in suo motu cases, there is no question of the Attorney General's mission. In fact, now there was a case when I was a very young lawyer, where a certain gentleman told Justice Ahmadi, something that either I am anti-national or you're anti-national. Justice Ahmadi thereupon called my senior, who was then the Attorney General, and said, "Mr. Attorney General, please assist us." And among the assistance that was provided was where contempt was in the face of the court, it was open to the contempt to say, please send it to some other bench to decide. That was even pointed out to the man, but the man said, no, we will go ahead with it. And then the Attorney General assisted the bench, and thereafter due process was followed. There is a procedural safeguard in the Act. If you do not resort to it, there will be mess-ups like the one we are currently seeing. Mr. Chaudhary has been advocated. He has the same position in the state or in a high. No, Anup Chaudhary has been an advocate general. He has an equivalent position in the high courts. Yes. He can tell you more possibly.
Mr. Chaudhary, do you agree with what Sanjay Hegde is saying here about that process and the checks and balances which are there, which were not used?
You're referring to me?
Yes. Yes.
Hello?
Yes, Mr. Chaudhary, that point to you, if you want to come into what Sanjay Hegde here was saying about the checks and balances that are in place, the role of an attorney general or an advocate general in such proceedings.
Yes, of course. That is exactly the role of the Advocate General and the state and the Attorney General for India. You are called Attorney General for the state. So these are the checks and balances which are incorporated in the law. But unfortunately, it was really very sad that the Attorney General was called and the whole day he was made to sit in the court. Such a senior man, I mean, this is not correct at all. This is not correct at all. If you wanted to take his assistance, you should have taken it. And I agree with Sanjay when he says that it is putting the cart before the horse. What is the point of getting the Advocate General here now? For what purpose? And then you are saying we don't need to take the Advocate General's permission. Then I'll again come back. It was not a suo motu criminal contempt petition. You made it suo motu. The Supreme Court bench made it suo motu. It was not suo motu as such, because they took cognizance of this tweet on an application moved by somebody without the support of Section 65B of the Evidence Act. And how could a private person, a lawyer who's moved that application, move an application regarding a tweet which is not supported by an affidavit as required under Section 65B of the Evidence Act? Yet it was taken cognizance of. This is not correct at all. It is at that stage the application should...
I want to just read out...
Yes. The application should not have been put up before the court unless there was a permission of the Attorney General. Or consent of the Attorney General was recorded. That was not done.
I want to just read out an excerpt from the statement. Yes, I want to just read out an excerpt from the statement made by the 12 former judges and other big legal luminaries, including Justice Rumapal, Justice G.S. Singhvi, Justice Madan Lokor, who's specifically spoken about it multiple times. Now, the statement says, to hold that such criticism shakes the foundations of the judiciary appears to be a disproportionate response. Effectively saying that to believe that, a simple tweet, a few 200, 300 words will actually shake the foundation of an institution like the judiciary is a disproportionate response. The hallmark of a strong institution is its openness to public scrutiny and commentary, and that actually goes for every great institution in a democracy. And this judgment will have a chilling effect on people expressing critical views on the functioning of the judiciary. I do want to again go back to very simple basics here, Mr. Kailash Vasudev, for somebody not very well versed with law to understand. What can we say? What shouldn't we say? Can we criticize a judgment? Can we criticize ongoing court proceedings? Can we criticize a sitting judge or a retired judge? As a common man, what can be done without it becoming a contempt issue?
This is an area where we are treading into troubled waters as of today. In 1978 was a classic case where Shamlal, who was the editor of the Times of India, wrote a scathing article on Justice M.H. Beg when he pronounced his judgments in the ADM Jabalpur case. So Chief Justice Beg, as he then was, took cognizance of the matter, sitting with Justice Kailasam and I think Justice Untwalia. So they summoned Shamlal to come into court, and he said that, look, you have committed the grossest contempt. You have made a scathing attack on my judgment and on me. So Untwalia and Kailasam, who were sitting on both sides of the judge, they said contempt is dismissed. Justice Beg, who was irked with the whole thing, wrote a 35-page judgment on what contempt should be. It was a single judge. I mean, it was a dissenting judgment to what the majority had done. I bring this to your notice for a purpose. It was a criticism of a judgment in the most scintillating and scathing language that you could think of. And it was accepted by two judges, not accepted by one. Therefore, I said you're treading in troubled waters. Some judges take criticism, some don't. Some judges accept the power which they have, others say, forget it, it doesn't matter to me. I'm here for a short while, I'm here to do my job, and I will go away. Time will test me. Today, we're not looking at what time will test the judges on. We're looking at what a judge can do when he's sitting there for the purposes of attaining his personal situation. I don't want to be nasty, but there is this movie, Two Popes. It is about Benedict quitting his post of years. So Francis scratches his head, looks at him very plainly, and he says, well, they climb on top of their egos and fall down. Today, we have that situation. We have too many egos, too many views of ourselves, and most importantly, after the 1993 judgment in the 1992 judgment in the Advocates on Record case, the dismissal of the rejection of the NJAC, it has become a very odd situation for all of us to see what we see in judges today. In the past, they didn't read newspapers, they didn't mix around, they didn't go to the press, they didn't look forward for publicity, they didn't want their statements to be made available in the press and the like. Today, they look forward to it. What will I say in court? What will the press carry? I must see it on TV, I must see it on Mirror now, I must see it on this channel, I must see it on that, because that is my perception. Voiced.
Yeah, Mr. Kailash Vasudev, unfortunately, we're losing the audio line with you, and I think that was the trouble. Even when you were quoting, that story from the movie, we'll try and fix that audio line with you and come back. Sanjay Hegde, do you also want to weigh in on this? It's a very common doubt that everybody has. I think even for some of us, when we were starting out in journalism and covering legal cases, it was always a big question. What can you criticize a verdict? Can you criticize ongoing court proceedings? Can you criticize a sitting judge, personal or professional?
You can criticize a judgment, no problem. The Supreme Court got it wrong the first time in 377. That's a criticism, no problem. You can criticize a judge also. That is the law. You can say he has horrible taste in clothes, for instance. That is criticism of a judge. But that will not be contempt. But if you criticize a judgment and attribute motives, then there is a problem. If you supposing I was a judge deciding a prohibition case, if you say that Judge Hegde is a drunkard, then that is not contempt. But if you were to say that because Judge Hegde drinks too much, that is why he, in his judgment, decided to quash prohibition in a particular state, then you're attributing motives to the judge. That would be contempt. And by the by, before I go, there is no earthly possibility of there ever being a Judge Sanjay Hegde. That's why I use the example.
All right, Mr. Hegde, thank you for playing so safe with that word and that name then. I wanted to, point taken, and thank you for also explaining this to our viewers, with those examples. Karuna Nandi, I was, when I was researching for this conversation, I came across an article that's been written in one of the digital portals right now by a senior journalist. And he's asking the question about why there is a difference in the response we're seeing today for Prashant Bhushan than what we saw for when Justice Karnan was, found guilty of contempt proceedings and sent to jail. And his repeated appeals right up to the president didn't really, elicit any response. There wasn't this kind of outrage that we are seeing today for Prashant Bhushan. His point being that's because Justice Karnan is an outsider. Now, what would your response be to that? And is the difference in response more to do with the two cases being very different? One having to do with a judge's order, the other one having to do with a lawyer's observation or critical comments?
I think that the allegation that is being made by a lot of people from the Dalit community, and let us remember that all of us on this panel are not Dalit, right? And this is regularly the case. So the allegation that is being made by the Dalit community is that the difference that is being made is because Justice Karnan was Dalit, and which is why the reaction is not what it should have been. And I think all of us must introspect with regard to that. I was in court the morning that this happened, and I must confess that perhaps this will be controversial, but I must confess that the nature of Justice Karnan's order and the nature of the tweets to me seemed dramatically different. And hence, I think that there is a difference in nature. I would like to quote from the Shreya Singhal judgment, which has defined the contours of free speech. And Justice Brandeis was cited in his famous concurring judgment in Whitney versus California with approval. After, of course, Justice Nariman looked at the close connection between US jurisprudence and Indian, because there's a misconception that it cannot be cited with the sort of strength that it deserves. Now, what was said here is that when the right to free speech was brought into the American Constitution, and they say here that they knew that order cannot be secured merely through fear of punishment for its infraction, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and the fitting remedy for evil counsels is good ones. We are in a very critical time in our constitutional democracy. We are at a time that for the last many years now, sitting judges and former judges of the Supreme Court have been making strong criticisms of the court. In such a situation, I do believe that it is particularly important for our courts to stringently follow textually the jurisprudence that comes before it. And of course, each case is different. But I think that that stringent following of law, that stringent following of processes is absolutely vital now because of this polarization. And that the court has spoken very wise words in various judgments, including in Shreya Singhal. And as members of the court, who have invested our lives in serving justice and serving the law and in our court, I think that the legal community, I won't say fraternity because I'm not a brother, but the legal community is very deeply concerned about what is happening today. And we have faith in our court, and we hope our court rises to the words of its own words in Shreya Singhal judgment.
Okay. So where do we go from here, Mr. Kailash Vasudev? You're back with us. I'm sorry we lost you halfway through the point you were making. Go ahead and finish that, please. And in this specific case, is there a scope for the bench, Supreme Court, to review their own verdict?
No.
What I was telling the story about the two popes was when Benedict asked Francis as to how the people die in Argentina. As well, they climb on top of their egos and fall down. Now, coming back to your specific question here, as to what the court will do. If you see the order passed today, it said that we're going to keep this the 25th of August. We are giving Mr. Bhushan an opportunity to file an apology, and we will unconditional apology, and we'll discuss what is to be done next. In this kind of an order which has been passed, saying either you file an unconditional apology or we'll see what is to be done, is a wide enough message to say that they don't intend to back what they did in the in the fall. August. Give it a,
But I'm so really sorry, Mr. Kailash Vasudev. Some days we just struggle with the network line with you. Mr. Anubja Chaudhary, would you want to come in on this one? Is there still possibility, as many urged the Supreme Court to reconsider, for that to be done?
Come again, please. I just couldn't catch what you were asking.
Yes. Is there
Hello?
a possibility for the Supreme Court to rethink its own verdict in this specific case, as so many people are urging the Supreme Court to rethink?
The way the court is proceeding, they can do it, but they won't do it. That's very clear. In fact, therefore, let's not expect anything else from them. The way the court has been proceeding, you can always guess that question of review does not arise at all. Otherwise, this judgment wouldn't have come. They're not going to review this judgment, because there was an effort made to say that we are filing a review. You hear on contempt that on that the judges have refused, and they've given him 2 days' time to consider. I don't know exactly, it's lifted on 25th August or what, but we gave him time to consider whether he would like to, very frankly speaking, they want an apology from him to close the case. And that Bhushan has said clearly that he is not going to apologize. Whatever explanation he has given has been given, and according to him, he is an officer of the court, and it is his duty to protect this court as well, and it was his duty to bring about things which he thought was not correct. That's what he had said. Now, Tanvi, you must understand all over now, this is taking a peculiar way. I don't understand why bar councils from different parts have to say we are in support of the judgment or against the judgment. I don't understand why all this matter is now almost becoming political now, which it should not. This is purely a question of law. It's not Bhushan-centric at all. And to view that a law of contempt would be differently applied to depending on the person who alleges to have been committed the contempt, that will not be proper at all. We are all saying that should the law in such criticism, law of contempt, be applied at all? Does the law of contempt attract itself, or it does not attract? Does it come within the parameters of the law of contempt? And does it come within parameters of Article 129 of the Constitution, which gives the inherent powers of the Supreme Court to punish for contempt of itself? Those are the issues which are here, and all lawyers have expressed it, not because it is concerning Prashant Bhushan. No, it's because it concerns not only the lawyers, it concerns the entire judiciary. Now, the independence of judiciary is as much dependent on independence of the bar. The independence of lawyers is as much required for an independent judiciary. Equally, I would say. Therefore, you can't just
well, Mr.
the line saying lawyers have to be treated differently, judges and former judges have to be treated differently. No, the motive behind criticism is to strengthen this institution. And let me tell you, this institution is too big, too strong, constitutionally and even otherwise, to be scandalized by one tweet. I'm so sorry. I think that is rather having a very weak view of the institution itself. Institution is big enough to tolerate all.
Yes, in fact, today's conversation also, Mr. Chaudhary, was more to do with the law, more to do with the contempt law, not really about specifically about one individual, whether it's whether it's Prashant Bhushan or anybody else, but more to do with the entire controversy around the contempt law and how and when should it be and can it be used. But I'm completely out of time, so I'm sorry I'm interrupting you there. But big thank you to all of our panelists who've joined us, Sanjay Hegde, Kailash Vasudev, Karuna Nandi, and Mr. Anup George Chaudhary. Thank you so much for speaking with us. As I wrap this up, let me also read out some of the comments made by the Supreme Court itself in the past, orders given by Supreme Court itself in the past in connection to contempt. And there was a case, the S. Mugolkar versus Unknown in 1978, where the Supreme Court said, judiciary cannot be immune from fair criticism. Contempt action to be used only when an obvious misstatement with malicious intent seeks to bring down public confidence in the courts. At times, judiciary adopts a magnanimously charitable attitude even when an utterly uncharitable, unfair criticism is made out of concern for improvement. Second example, as I wrap this up, was about a case of contempt proceedings against a journalist who had put up a post on Facebook, and the Punjab and the Haryana High Court at that point actually had held the journalist in contempt. But Supreme Court said this is not a case where the contempt action should have been taken as against the appellant, who is an advocate. Viewers, it's not about sitting here and going into the merits of the Supreme Court's decision, but we brought you the views of those who have spoken up about it and who believe that this was perhaps not right. Prashant Bhushan has refused to take it back, refused to apologize. He said, I don't even want you to give me 2 more days' time. I am not going to change my mind. Nevertheless, the Supreme Court has given him 2 days of time. Otherwise, they will decide what has to be done next. But biggest of the lawyers, retired Supreme Court judges, and even politicians are speaking up about it. We'll keep you posted on what happens next. Thank you so much for joining us on this conversation.